I call the first case on this morning's docket. That is case number 112955, State of Kansas v. Northern.
May it please the Court, Samuel Shire appearing on behalf of the defendant appellant, Mr. Northern. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. Mr. Northern is appealing from a ruling that he may not file a notice of appeal out of time. Unless this Court desires otherwise, I'd like to begin with the first issue raised in the brief, which is the preliminary question of whether there is a final sentence in this case. Obviously, if there is no final sentence, then the deadline to file a notice of appeal has not yet begun to run.
Counsel, before we proceed with that, for the benefit of our visitors, would you mind giving us about a 60-second recitation of the facts that brought us here today?
Yes, Your Honor. In 2010, Mitchell Northern was charged with premeditated first-degree murder. At the end of 2011, he pled guilty to that charge. He received a life without the possibility of parole for 25 years, sentence in toward the end of 2011. At that time, the district court advised Mr. Northern that he had 14 days to appeal the district court sentence. Approximately 1 month later, the district court imposed a restitution order. And then about 2.5 years after that, Mr. Northern filed a motion to file a notice of appeal out of time. Generally, the rule in Kansas is, in a criminal proceeding, a defendant has 14 days to appeal from the judgment of a district court. So Mr. Northern asked the district court for permission, based on a case known as State v. Ortiz, to file an out-of-time notice of appeal. That motion was denied and appealed, and we are arguing before this court today that the denial of that motion was incorrect.
Very good, thank you.
So the preliminary question that we raised in issue 1 in the brief is whether there is a final sentence.
Can I ask you a question beforehand? Which Ortiz exception are you claiming to be covered by?
Pardon me, Your Honor?
Which Ortiz exception are you claiming to be covered by here?
Your Honor, we're
we
claiming to be covered by the third Ortiz exception, and in the brief we asked a remand on the first Ortiz exception. The first Ortiz exception would be that the district court did not properly advise a defendant of his right. So as to whether a sentence has been imposed, restitution is part of a criminal defendant's sentence. That's well established. It's also well established that a sentence is not complete until restitution has been imposed. And we would also note that by statute, sentencing is required to occur in open court. So the argument that we're making to this court today is fairly straightforward. The district court imposed restitution through a written order. We don't think that that is a statutorily permissible manner through which the district court could impose a sentence. And for that reason, we believe that a sentence has not been imposed and that the appropriate remedy would be for this court to remand this case with instructions for the district court to impose a restitution sentence in open court, and then that Mr. Northern would have 14 days to appeal from that decision.
How do you distinguish Frierson and Moncla?
Your Honor?
Are you just basically saying we were wrong or too lenient or too loose in those cases, or what's your position?
I think the way that they could be distinguished is that Moncla and Frierson did not address the exact statutory issue that we're raising today, that it is not statutorily possible to sentence a defendant with a written order. I think what happened in this case would not be any different than if a district court attempted to impose a prison sentence simply by filing a journal entry of judgment. I think that would be clearly impermissible. I think that the sentencing would have to occur in open court, regardless of whether a defendant waived his or her right to be present. And I don't believe that a restitution sentence, since it is part of a defendant's sentence, should be treated differently.
Hall essentially said that we were going to be strict henceforward about that. And Fearson and Hall and Charles were all kind of a group of cases that were decided at the same time. But Hall had a different outcome from Fearson, because in Fearson we said this is going forward. And you're just saying we can't draw that line as a court? We can't say the prior law, which frankly applied at the time of your client's sentencing as well. I mean, he's in the same procedural posture as Fearson in terms of the timing of his sentence, right?
Yes, Your Honor.
And in Fearson and Moncla, we said a little more relaxed standard will be applied for a defendant who was sentenced before the date of the Fearson opinion. Is that pretty?
That's accurate, Your Honor.
Yeah, pretty brief summary of what they said. But your client falls there. So what's different? Why doesn't he fall under the more relaxed rule applied in Fearson and Moncla because of the date?
Well, as far as the relaxed rule, we would respectfully submit that was a wrongly decided aspect of Fearson and Moncla. And we believe it was wrongly decided because the appellants in that case did not raise the statutory argument that we set forward in our brief today.
Okay.
Unless this court has further questions on that issue, I would move ahead to the Ortiz issue. There are 3 exceptions which will permit a defendant to file a notice of appeal out of time. With respect to the first Ortiz issue, I think it's pretty clear from the record that the district court gave Mr. Northern the wrong statutory deadline for filing a notice of appeal. Given Court of Appeals case law and this court's case law, the deadline for filing a notice of appeal did not start running until 14 days after the imposition of restitution. So I think we've met the first step in a pattern analysis. Moving to the second step, I don't think that the state can demonstrate that Mr. Northern would not have filed a notice of appeal had the district court advised him of that right following the imposition of restitution.
Is that the burden? Or is that flipped? Is that Mr. Northern's burden to show that he would have, not the state to show that he wouldn't have?
Well, it's the 3-part test, Your Honor, and on part 2, it's the state's burden. And then when you move to part 3 of the test, Mr. Northern has the burden. And that's why we would be asking this court for a remand today, so that a district court could make factual findings.
And under which exception? Because I think you're saying that wasn't raised below.
That was not raised below, Your
And
Honor.
under which exception to allowing you to raise it on appeal, or how are you getting there?
Your Honor, I think that this court can address the issue, although it was not raised below, because it implicates Mr. Northern's fundamental due process rights. So to protect that fundamental right, I think this court can address the issue for the first time on appeal. And I think it's important to note that the record does not reflect that this issue was considered and abandoned by trial counsel below. I think while this case was being litigated in the district court, everyone was under the impression that the district court gave the proper statutory deadline for filing a notice of appeal. Mr. Northern, his attorney, the state, the district court judge, everyone was under that impression. And I think as a matter of law, the district court simply did not give the right statutory deadline in this case.
If you don't win on your first issue, where are we at with Ortiz then?
Basically, the first issue, you're claiming that he was not properly informed of his right to an appeal.
Yes, Your Honor.
And if we find you don't prevail on that issue, there was an Ortiz hearing, wasn't there?
Yes, Your Honor.
And the court made a credibility determination based upon what he heard at that hearing that your client was informed of his right to an appeal. So where are we at if you don't prevail on that first issue?
Well, with respect to the third Ortiz exception, I think this court's standard of review is whether the district court's ruling was supported by substantial competent evidence. And it is our position that it was not supported by substantial competent evidence, and that Mr. Northern's testimony should have been deemed to be credible. Obviously, if it was deemed to be credible that Mr. Northern asked his attorney to file a notice of appeal, that would have been, those would have been facts requiring application of the third Ortiz exception.
What was there to appeal?
In terms of the sentencing, he got what he bargained for, concurrent sentence to the minimum sentence that's allowable by law. What is there to appeal in this, in terms at least of the sentence that was imposed?
Your Honor, two thoughts. Number one, everybody has a right to appeal by statute,
Right.
whether it's going to win or lose. And so I think that right to appeal has to be respected. And number two, the restitution ordered in this case certainly could be appealed. And from the record, it's not clear whether Mr. Northern was aware that restitution was imposed in this case or whether he agreed with the amount of restitution ordered in this case. And so I think that's definitely an issue that could have been raised in an appeal. Unless this court has any further questions.
I'm still trying to unwind whether or not us having the ability to reach that first Ortiz exception that wasn't raised below ends up being dependent upon the resolution of your first issue. I mean, do we have to say as a matter of law that you have made a successful argument there in order to say that the first Ortiz exception applies? In that, to get to the point of saying that the advice was incorrect?
Your Honor, I think the first issue and the second issue are not really aligning harmoniously in terms of their application of the law.
Ultimately, but are there at least several steps that track in terms of an analyzing that the restitution is part of the sentence, that the sentencing has to be in open court, those sorts of things? We have to follow along some of the same path?
Yes, Your Honor. Where I think the issues diverge is issue number one is maintaining no sentence was imposed. If this court disagrees with issue one, the sentence would have been imposed. Yes, Your Honor?
Well, go ahead and finish your thought.
Sentence would have been imposed when the restitution order was signed by the district court judge, or at least when it was filed by the district court judge. And at that point, that's when the 14-day deadline to file a notice of appeal would start to run.
You indicated or intimated that there was a change of law after this sentencing, or at least a change in understanding of what the law was. And that partially has to do with whether you filed an appeal within, before the restitution hearing, whether that was premature or not. And if it was premature, whether it was held in abeyance until the restitution order was entered. And so all of that came about with cases after the fact, after this sentencing, did they not?
Yes, Your Honor.
And so part of what your argument is that the reason that it's amenable to first time on appeal consideration is that we have a change in the law. Is that what you're arguing? Change in the law from the time it was sentencing was had. So what was thought to have been correct advice turned out to be incorrect advice because of later cases.
Well, Your Honor, I wouldn't entirely agree with that. I think the law really was unsettled when the district court sentenced in this case. I don't think it was clear one way or the other. And given that ambiguity in the law, I think the court would have been advised to apprise Mr. Northern of his right to appeal.
So, certainly the statutes
Twice.
didn't change.
No, Your Honor. Unless this court has any further questions, I see that I am out of time on my initial argument.
I see no more questions. Thank you, counsel.
May it please the court, Cheryl Lidkey, Chief Deputy District Attorney, Wyandotte County, on behalf of the state. I just wanted to draw the court's attention, I'm sure you're aware that there's a companion case with this defendant that was heard on the summary calendar docket with the Court of Appeals January 13th with this same issue, issue number 2. With regard to our issue number 1 in this case, the defendant did file a 609 letter on October 21st citing the Moncla case, and as I read through that, I took that as an apparent concession that the sentencing was final when the restitution order was filed on December 11th, 2011. Apparently they're not conceding the issue, they're just aware that the Moncla case does exist, and our argument is that the facts in this case are no different. They're not distinguishable from the Moncla case in terms of the restitution order issue. This is clearly a case where at the sentencing hearing in open court, this defendant was aware and agreed to leaving the restitution order open for 30 days. Later, a journal entry memorialized the restitution order and was filed on December 11th, 2011, a couple of months after the original sentencing date. And so those are the same facts from Moncla. Moncla had a situation.
Let me pose what I understood to be a suggestion from counsel was, what if it was flipped? What if they had ordered the restitution in open court and said, I'm going to think about whether I want to do the aggravated or mitigated or middle sentence or whatever, and then I'll do that by journal entry 30 days from now. Would that be sufficient?
No.
And what is the difference if they are both the term of imprisonment and restitution are by statute part of the sentence, and we've said it's all has to be done before your sentence is final?
Well, I think there's we're not debating the validity of the restitution order in this case. We're debating whether or not sentencing was considered final. And if you look at the language of the Moncla case and the Frierson case, they talk about whether the spirit of the statute was satisfied. And I think if somebody isn't actually a sentence, a term of months is not imposed upon the person at their sentencing hearing, I don't think you could come close to saying that the spirit of the statute was complied with. But you can with the flip of that, where a restitution order is ordered, but the amount is left uncertain. So that's how I would distinguish it.
Well, I'm having trouble understanding if you ordered that you're going to be sentenced out of this grid box, but just which of those numbers are going to apply. I don't see any distinction from saying we're going to do restitution, but we're going to pick a number later. I mean, I don't see how you could be intellectually honest and say they're not the same.
I just disagree with you. I think to say we're going to sentence you to a number of months when we don't know what that number of months is completely different than saying you're going to have to pay some restitution. We're not sure what that amount of restitution is going to be, but we're going to allow you and your attorney to review that and come to an agreement on it later. Is far different from a court saying, I'm not sure what sentence I'm going to give you yet. What term of months I'm going to give you.
If you order someone to pay money, that's a liberty interest that implicates due process, does it not? Just the same as if you order someone to prison. Those are both orders of the court that implicate due process.
I would agree,
Yeah, okay.
but we're not talking again about the validity of the restitution order. We're not talking about the validity of his sentence in this case. We're talking about a collateral issue, and that is whether or not the sentencing was final in terms of his ability to appeal. And as I was arguing, I don't see any distinction between the facts in this case and the Moncla case. And so our argument as to issue 1 is that the defendant's 14 days began on December 11th, 2011, and clearly when he filed his notice of appeal on May 19th of 2014, he was clearly out of time. As to issue number 2, the lower court properly denied the defendant's request to file out of time. There is substantial competent evidence on the record from the Ortiz hearing that established that there was no exception that permitted this appeal to be filed out of time.
When the district court judge made a credibility determination, one of the things, at least that was articulated on the record, was his past experience with this particular lawyer, that he's appeared in front of him on numerous occasions. He's taken appeals from other cases. Is that outside the record consideration, that part of the equation,
No.
appropriate at all?
Well, no more so than when this court has said it's not going to weigh in on credibility issues, that a judge in the district court has the ability to see the witnesses testify and to hear how they testify. Those are things outside
You have
of
an opportunity to see the witness testify, and in this case it was Mr. Carney. He saw Mr. Carney testify, but what he took into account was his other experiences with Mr. Carney. And I just want to ask you, is that appropriate to do? That's outside the record of this case. I don't know.
I could see where
Well,
that.
I mean, basically, the judge is almost a witness as to his credibility based upon prior experiences. You really can't cross-examine the judge about that.
I agree, and I see how that can be problematic, but I would like to remind you that this isn't a situation where the credibility was being weighed because they were saying opposite things. The defendant was vague. The defendant was not contradicting what his lawyer said. He was just not sure about it. The lawyer was certain, and I think perhaps the comment was inappropriate by the judge, but the judge's final decision, I think, was supported by substantial competent evidence. The defendant is asking for apparently a remand on whether or not he was properly advised about his appeal rights, the first exception under the Ortiz test. But in order to get that remand, he really is asking this court to allow his appeal on that issue. Our argument in the brief is that no, he hasn't properly preserved that issue for an appeal, and he shouldn't be allowed to switch up his claims on appeal when he had ample opportunity in the lower court to raise it on that issue. He had admitted in the lower court and in his motion that he filed that he was properly advised of his appeal rights.
Was he, though? Was he properly advised if taking our case law that says the sentencing isn't final until an appeal isn't proper until the restitution order is entered?
At the time of his sentencing, he was properly advised of his rights. The Hall decision didn't come out until 2014, I believe.
So the Hall decision made the advice of the judge improper advice.
Well, I'm not sure that you can argue that, and I'm not sure that
Well,
defendants get the benefit of all changes in the law.
So that wasn't retroactive
Well,
to cases pending on appeal?
I haven't analyzed that, but my gut is that no, it would not be.
But the bottom line is what the judge told the defendant about 14 days from the sentencing hearing was what everyone thought was the correct advice at the time.
And it was.
And after Hall, arguably the correct amount of time is 14 days after the subsequent restitution order. And why isn't that change enough to make this an exceptional case to hear it for the first time on appeal when it couldn't have been raised, Hall couldn't have been argued in the district court because it didn't exist?
Well, even if you follow it that way, then there's a later modification or interpretation of the law with Moncla and Frierson. And so really what was the state of the law? What should the judge have told him at the sentencing? That so long as the statute was substantially complied with, and when the order was filed, that it was final then?
Did Moncla and Frierson change the date of appeal?
Well, no, but what they held was that the date that the sentencing was final was when the journal entry was filed.
Of restitution.
Correct.
So they allowed subsequent restitution order to stand, but they didn't change Hall's appeal date.
Well, the issue of whether it was a valid order wasn't addressed in Moncla. The issue was whether or not the sentencing was considered final when the journal entry was filed, which is the same issue in this case. And so it was final in December of 2011 in this case. And so he would have had 14 days from that date.
Counsel, what was the date on the attempted notice of appeal here? The late notice of appeal?
May of 2014.
Okay, a few months after Hall, Frierson, and Charles were decided.
May 19th. Yes, I think it was decided in March.
Okay,
Right.
thank you.
So really this comes down to the only thing that's properly preserved in this appeal is whether or not his attorney failed to perfect an appeal. And the judge decided that there was not enough evidence to prove that. And we believe that the evidence that was established at the hearing supports that, the judge's finding on that. His attorney didn't fail to perfect an appeal because he was ineffective or because he made a mistake. Together they talked about the fact that they weren't going to file an appeal. His testimony on this was clear, or his lawyer's testimony was clear, that they had a discussion that there essentially was nothing left to appeal. He had entered a plea to the murder charge. He'd gotten the presumptive sentence to the murder charge. He had benefited because the other case there was an agreement to run it concurrent with this one, and the state gave up asking for the hard 50. So clearly the lawyer's testimony was that they did talk about doing an appeal. The defendant then said, yeah, we had that conversation, and after we did so, I never asked him again to appeal this on my behalf. And the defendant really had no explanation for, even after all of this, he waited almost 3 years to file his notice of appeal, except that he had talked to some other inmates and wanted a chance to get back into court to try to get his sentence reduced. So even today, there's no claim that his plea was involuntarily given or that any of his due process rights were violated, any of his constitutional rights. There's not a claim of actual innocence here. And I know that you don't look at the merits of whether or not an appeal should be filed in this case. It certainly is a consideration when you're looking at the overall fundamental fairness and whether it requires that he be allowed to, for instance, argue his first issue that he wants to remand back to the lower court. So we would ask that you find that there is substantial competent evidence supporting the judge's denial at the Ortiz hearing and find that this appeal basically was filed out of time and cannot proceed.
Any questions? Thank you, counsel. You're reserved 3 minutes for rebuttal.
Thank you, Your Honor. Unless this court has any additional questions, I'm prepared to waive rebuttal at this time.
I see none. Thank you, counsel. And thank you both for your arguments this morning. Court will take this matter under advisement.